How should plaintiffs weigh ethical considerations in settlement decisions, especially when settling might allow the defendant to resume non-compliant practices that could impact public safety or industry standards?
Yeah, I think this is a good question. So I'll go ahead and repeat it again. If you are, say you're a business and you are bringing a lawsuit against another business and you are offered a settlement, and you've got to think about, should I accept this settlement if it will allow someone to engage in what they believe to be unethical practices going forward or non-compliant practices? And I think this is a really good question because it reflects upon any time a business owner or a business is bringing a lawsuit against another business. And in fact, I would say it's relevant whether you are defending or bringing the lawsuit, but particularly if you're the one initiating the lawsuit, you must go into it with a view of, what is my purpose here? Um, the lawsuit itself is a tool. It's a tool to accomplish something that, generally speaking, the business owner doesn't believe can be accomplished unless you do the lawsuit, because it's usually seen as something that is a matter of last resort. Now, I have represented companies who, for very good reasons, used a lawsuit as a strategy. And lawsuits were not a last resort. Lawsuits, especially from a plaintiff perspective, were something that they immediately started to prepare for and tee up by sending out cease and desist letters and making it a forward part of their strategy for very good reason based off of their particular goals. And that's the key. It's all around, what is the purpose here? What is the higher purpose and good that you're servicing? This is, I think, where a lot of law firms and lawyers get it wrong, in that we can elevate our own intellect and our brain power and make that the biggest thing in the room, the biggest thing that matters to clients. And that's not the reality of it. The reality is that every single one of our clients, they have a dream and desire and purpose that goes far beyond the legal work itself. And one of the things that we're really keen to do is to make sure that the work that we do is mindful of the fact that there is a higher purpose and that our work is designed to be in service of that higher purpose. Now, sometimes people view the higher purpose as, well, I want to get whatever that immediate thing is that the lawsuit is demanding. So if it's demanding that someone cease and desist from doing something, a lot of times people view that as the higher purpose. Or if it's looking for damages or for someone to pay on a contract, they will view that as the higher purpose. But I honestly believe that's really the immediate outcome that you're looking from the lawsuit. In truth, there's probably something even more that you want, because what is the purpose of that money, right? That you're looking to get, the damages that you're looking to collect. If you're looking to have someone stop doing something, what is the purpose of them stopping? What goal and what higher good would that service? So a lot of times people will go into a lawsuit and they don't actually care about the money. They care more about something else. What is the something else? And what does that something else do for you? I could give you an example where plaintiffs very often have in their mind a higher good and purpose that they are looking to achieve. So recently we've seen an increase in the number of lawsuits filed for non-compliance of websites with the Americans with Disabilities Act. What a lot of people don't realize is that a website has to be compliant with the American with Disabilities Act if that website is being held out in a way and in connection with a business and services that are required to be ADA compliant. And quite frankly, there this is almost every business, right? It's so many businesses that would be subject to these requirements. You might find yourself in a jurisdiction or with a business model that doesn't have to require to comply with the ADA when it comes to their website, but oftentimes that's not the issue, right? When it comes to defending it, that won't be a successful basis. Sometimes yes, but oftentimes not the case. And in those instances, those are plaintiffs who have a disability that limits their ability to fully utilize the website. Typically, these are plaintiffs that are visually impaired. They have some degree of blindness, right? And so it impedes their ability to utilize the website without using screen readers and other adaptive software that's readily available. And so the key is your website set up to make it possible for them to utilize your website on same terms, similar terms as those who don't need the adaptive software. And sometimes, depending on what people put on their website, the features, the pop-ups, all of these various things, it does not actually get picked up on the screen readers, and it's not visually something that the individual can see or discern from looking at the website. And so that's a situation where you have plaintiffs where typically their approach to it is what they view as a higher purpose. They might ask for a period of compliance over the course of several years and monitoring and check-ins because they view their role as being of service in the sense that they are helping to make the website compliant for all of those who are visually impaired and not just themselves. And so, but that mechanism for filing a lawsuit allows people to pursue it on that basis, to be a representative of a class of people who are looking for relief. And so when you bring a lawsuit, you really want to think about what is the higher good that I am servicing, because it's hard to evaluate if a settlement is truly appropriate for your interests and needs if you aren't really dialed in to the higher purpose. It can also be easy to get dissuaded and to feel frustrated around the progress in the lawsuit, the delays, the time it takes, or the cost if you aren't clear about the outcome. What would a successful outcome look like? So that's a very good question to ask yourself at the beginning is, what does success look like for me when it comes to this lawsuit? I think for every single lawsuit we file, we have a form that we fill out with clients where we ask them their objectives for the lawsuit. We actually, I think our malpractice insurer requires us to do this, but it's such a pattern and habit that I have from representing plaintiffs in lawsuits, businesses that are plaintiffs in lawsuits, that I just understood it to be the common practice that occurs. And the whole reason is because you want to be dialed into your why, as people put it, when it comes to that. So when it comes to this question of what happens if the defendant might be non-compliant, how do you accept a settlement? Well, you look at the settlement terms and you see if there's a way to incorporate that into the settlement terms. That could be something that is an option for people to if they see the purpose of the lawsuit in terms of addressing compliance issues. It could be that you feel that now there is another standard or another method of ensuring compliance that doesn't require your lawsuit to help achieve that. So I think those are really good starting points. Litigation is so charged and it's so emotional, and anybody who says that it's not, that it's purely logic, I would dare them to get into the room with the actual parties who are making the decisions, who have the power to settle, and see if they really believe that. Because every time I've been in a mandatory settlement conference or mediation where the principals are required to be in the room with the judge, who is usually the mediator if it's court-ordered mediation with the magistrate, then you get to see that it is a very emotional prospect. We tend to think businesses aren't emotional, but businesses are run by people. So, or as some say, businesses are run by systems and the systems are managed by people. But at the end of the day, especially around litigation, it's going to be a person who makes that decision or a group of people who make that decision. And I would suggest that the system that they should use around settlement would be evaluating the purposes of the litigation, with also some other factors when it comes time to settle. So, Anna,